Welcome, everyone. Welcome to the Consumer Financial Protection Bureau's field hearing in Portland, Maine on the issue of debt collection. The Consumer Financial Protection Bureau is an independent federal agency whose mission is to help consumer finance markets work by making rules more effective, by consistently and fairly enforcing those rules, and by empowering consumers to take more control over their economic lives. My name is Zixta Martinez. I am the Associate Director of External Affairs at the CFPB. Today's field hearing is being live streamed on our website at consumerfinance.gov, and you can follow CFPB on Twitter and Facebook. We'll begin today's field hearing with remarks from Maine's Attorney General Janet T. Mills and the Superintendent of Maine's Bureau of Consumer Credit Protection, William Lund. Next, the CFPB's Director, Richard Cordray, will provide remarks on the Bureau's most recent work in the area of debt collection. Following Director Cordray's remarks, Assistant Director Corey Stone will lead a discussion with a panel of experts on the topic of debt collection. Following the panel, we'll kick off the audience participation portion of the field hearing. This portion provides audience members with the opportunity to share their stories and your observations about what you are seeing and experiencing in consumer finance in your community. Today's audience includes community leaders, advocates, industry representatives, and of course, consumers. We are pleased to welcome staff from the offices of Senator King, Congresswoman Pingree, Congressman Michoud of Maine, as well as staff of the office of Congresswoman Shea Porter of New Hampshire. Also with us today are elected state and local officials and their staff from Maine, New Hampshire, and Vermont. Thank you all for joining us today. So let's get started. Our first speaker is Janet Mills, who was elected last year to serve as Maine's 57th Attorney General. This is not General Mills' first time in the Attorney General chair. In 2008, she was elected as Maine's 55th Attorney General and became the first woman to hold the office of Attorney General in Maine. Prior to her election as Attorney General, General Mills served in the Maine House of Representatives, representing the towns of Farmington and Industry. She served on the Judiciary Committee, the Criminal Justice and Public Safety Committee, and the Appropriations Committee. She also taught in the Justice Studies program at the University of Maine, Augusta. During her time in office, Attorney General Mills has been on the forefront of consumer protection. Most recently, she announced last month that over 1,300 Maine citizens were going to begin receiving checks to compensate them for robo-signing abuses as part of the National Mortgage Settlement. Attorney General Mills, it is my pleasure to welcome you to today's field hearing.
Thank you, Ms. Martinez. Thank you very much. Thank you very much. As she mentioned, I am both the first and second woman Attorney General in Maine. That'll be on Jeopardy one of these days, Director Cordray. It's a pleasure to welcome you to Portland, Maine, those of you who are not from Portland, Maine, to talk about debt collection. It's an odd thing to talk about on a beautiful summer day like this, but really a necessary topic to discuss. You know, I'm old enough to have heard about the Great Depression. Growing up, learning about it from my grandparents and my parents, aunts, uncles, and elders in the community. At that time, credit cards were unheard of for that generation who lived through those very hard times. Credit was like putting something special, a special suit or dress on layaway at Peck's or Sears or Ward's until savings accrued to pay for it and you could take it home free and clear and it was yours. You didn't keep paying for the item. And then the mass production of cars and trucks in the 20th century brought loan companies specializing in paying for vehicles over time. And is there anybody in this state that doesn't owe money on a vehicle? The post-war housing boom of the 1950s engendered a mortgage loan industry that has grown by leaps and bounds, while mass production of appliances and toys and manufacture of clothing led to volume consumption and consumerism and very intense competition among these businesses. Good credit has become like a judge of character, second only to religion in some circles. Debt is now sold on TV, on radio, on the internet, among national and international banks and financial institutions, as Americans of all ages are bombarded with ads that rival the seductive cigarette commercials of the 50s and 60s. Post-secondary education, whether for-profit or non-profit institutions, they've been enslaved to federally insured loans as much as they are to endowments. And now we are told that outstanding student loan debt has surpassed outstanding credit card debt. And student loan debt relief ads are crowding the airwaves and the internet, some of them sponsored by outfits which extract an upfront fee simply to enroll a debtor in a federal program that is already generally free. So when the recession came crashing down a few years ago and the subprime mortgage crisis brought the economy to its knees, those who were drowned in debt, whether for school or for appliances or cars or mortgage loans, they had no escape, no recourse, and often very little understanding of the cause of the crisis. We heard a lot about the failure of Wall Street and the suffering of the major institutions on Wall Street, the big banks, too big to fail. But we heard very little about the suffering and the real-life hardships of those consumers who were brought to their knees by subprime mortgage lending and by the debt crisis that affected every family in this nation. Now, pop-ups on the social media pages of millions of consumers' computers advertise debt relief services, and they're as plentiful as the spuds sprouting in the fields of Aroostook County in July. No, this is not your grandmother or grandfather's debt service or layaway plan with Wards or Pecs or Sears. Debt is an industry. It's something my grandparents would never comprehend. And the question for us now in the public sector is how to separate the predators from the benefactors, how to regulate without depriving consumers of legitimate market choices, how to protect them from themselves in many cases. The question also is how to rein in unconscionable debt collection practices and debt relief services while permitting legitimate businesses to provide needed credit for consumers who see tough times. In Maine, we've seen a rise in student debt. We've also experienced an increase in our senior population. We're the grayest state in the nation, as we read in the paper every day. And we have seen seniors being preyed upon by unscrupulous creditors, some of them, leading them to conclude that they'll need to work until the day they drop if they're going to support themselves, protect their meager Social Security income, and perhaps even leave a piece of prosperity or security to their loved ones. So in Maine, these are some of the challenges we're facing, and we look forward to working with the federal government, and particularly Rich Cordray, Director Cordray, and the Federal Consumer Credit Protection Bureau in addressing these challenges at every level. We also have a very active Consumer Protection Division for some 40 years since the adoption of the Unfair Trade Practices Act and Debt Collection Practices Act since that time. And we work very closely with Superintendent Will Lund, and I'm glad to see him here today and to be conversing with him about our mutual issues. And we are pleased to work with him on litigation. We've brought 3 or 4 major pieces of litigation in the last year and a half on debt collection practices. And I'm here to share those experiences with you and to learn from this audience how we can do our jobs better. So I want to welcome you to Portland and to Maine in particular, and welcome Director Cordray and the Federal Consumer Protection Bureau to our beautiful state to discuss these interests, these issues of mutual concern. Thank you very much.
Thank you, Attorney General Mills. Our next speaker is William Lund, the Superintendent of Maine's Bureau of Consumer Credit Protection. Superintendent Lund has led the Bureau of Consumer Credit Protection since 1987. He and his staff oversee many aspects of the consumer finance industry, including non-bank mortgage lenders, debt collectors, loan brokers, retail creditors, money transmitters, credit reporting agencies, and non-bank ATMs. His office administers credit-related statutes and protects consumers by conducting compliance examinations, responding to consumer complaints, issuing licenses, and providing consumer education and outreach. If it all sounds familiar, much of it is the same as what the Consumer Financial Protection Bureau carries out. So much so that I wonder how much we may have borrowed from Maine and Superintendent Lund. Superintendent Lund, welcome. Thank you for joining us.
Thank you very much, and welcome to Maine and welcome to Portland. General Mills, those were outstanding remarks. I didn't necessarily appreciate your looking to me when you talked about Maine being the grayest state in the nation, but I'm most pleased to be hosting Director Cordray, other administrators of the CFPB, fellow regulators from New England states, and even the Commonwealth. We'll have a chief district court judge here either now or later today, and many other distinguished guests. My name is Will Lund. I work with about a dozen folks up at the State of Maine's Bureau of Consumer Credit Protection. As you've heard, I do feel, or as you can sense, I do feel a great kinship with the federal CFPB. First, the names of our agencies are amazingly similar. Consumer Financial Protection Bureau versus Bureau of Consumer Credit Protection. In fact, they're so similar that nearly every day we receive consumer complaints from Nebraska and Iowa and other states from consumers there asking for our help. We've developed a very rapid referral process to jet those complaints down to the federal regulators. Secondly, as you've heard, with the exception of depository institutions, which my agency does not regulate, our jurisdictional areas are very, very well lined up. From truth in lending to fair credit reporting to fair debt collection, RESPA, ability to pay standards for mortgages, and so on. In terms of the number of programs, we are ahead and we will remain ahead for years, in my judgment, unless the CFPB gets into such notable areas as rent-to-own, pawn shops, non-bank ATM terminals, and litigation funding providers. So I think we're safe in that race so far. And third, I feel a kinship with the CFPB because they have, some would say stolen, I would say hired away many state regulators to fill their ranks, so that when I am asked to meet with the CFPB, it's as if I'm at a state regulators conference. The CFPB is beginning to understand what we state regulators have known for a long time, and that is that it's very difficult to provide real protection to consumers. I was talking to a CFPB staffer about 6 weeks ago, and I said that I was going to be watching very carefully to see whether their high level of consumer response was going to remain, because it started out, or has started out, very, very strong. In the early days of the CFPB, in my opinion, many creditors simply asked or replied by giving or by providing whatever relief was requested, because, quite frankly, they were intimidated by the CFPB. So now we will see whether that high level can continue, and so far I think that it will. The folks I've talked to at the CFPB, I've told them that if creditors begin sensing that they are receiving form letters rather than careful analysis of consumer complaints, that they'll begin responding with form letters, and that really doesn't get to the root of consumer assistance. The staffer responded by saying that they are really becoming or close to being overwhelmed, or at least there's a danger of them being overwhelmed by the numbers of complaints, and that the complaints are very complicated. Again, that's something that state regulators have known for a number of years. So I welcomed him to our world. I've done some prosecuting in the past, some defense work, and some plaintiff's work, and I think it's best to think of each consumer case as a legal case that walks in your door. You get some facts from your clients, you get some facts that your client doesn't tell you and that you won't know until you go out on a limb for that client. You've got a law or regulation to apply to the facts. You've got limited resources and time, and you've got a host of other cases calling for your attention. You get complaints if you do things in a way that the consumer is not happy with, and if you get, in many years, an occasional thank you note for a job well done, it's so rare that you post it and frame it and put it on your wall. Debt collection is a large part of what we deal with here in Maine, and I'm delighted that the CFPB is focusing on that issue, especially in the area of payday lending, a collection of payday loan debts. We need all the help we can get, and I welcome their participation. I think it's great that the CFPB has come to Portland. I think it's great that regulators from other New England states have traveled here to join us. I think it's great that lawyers and industry representatives are also here today. It's a daunting challenge to provide effective consumer complaint while still recognizing the legitimate business practices of the majority of the members of the industry out there. We are partnering in every way possible with the CFPB to continue to do our best to help consumers. We are working to have access to the portal of consumer complaints so that we can, again, effectively help Maine consumers. So I am just delighted to be able to be here today to welcome you and to participate in this morning's and this afternoon's activities. So thank you very much.
Thank you, Superintendent Ludd. The next speaker is Richard Cordray, who became the CFPB's director when he was appointed by the President on January 4th, 2012. Prior to his role, Director Cordray led the CFPB's Enforcement Office. Before that, he served on the front lines of consumer protection as Ohio's Attorney General. In this role, he recovered more than $2 billion for Ohio's retirees, investors, and business owners, and took major steps to help protect its consumers from fraudulent foreclosures and financial predators. Before serving as Attorney General, he also served as Ohio State Representative, Ohio Treasurer, and Franklin County Treasurer. Director Cordray.
Thank you, Zixta. I want to especially thank General Mills and Superintendent Lund for the both illuminating and actually quite personal nature of their comments. And we do apologize for fishing among the ranks of the state regulators, but we've gotten some of our best people from there, so we don't apologize too sincerely. Also, welcome and thank you to all of you who've taken your time to be here today. We're here for this field hearing to say more about a very difficult marketplace, which is the marketplace for the collection of consumer debts. This topic has long been a source of frustration for many consumers, practically, I'm sure, for as long as there has been consumer debt, generating a heavy volume of consumer complaints at all levels of government. This subject is also the focus of considerable enforcement activity by the Federal Trade Commission, including yesterday, by state attorneys general, and most recently now by the new Consumer Financial Protection Bureau. We're all determined to make steady progress together to protect consumers in this area, and it will take all of us to do that. Debt collection also has more salience today than perhaps at any time in our country's history. In the wake of the recent financial crisis, we see far too many people who've fallen into financial difficulties. Many lost their jobs, many lost their savings, and even their homes. Bills piled up and sat unpaid. Many consumers fell behind, either because of bad decisions they made or because they were victims of predatory practices or just of tough economic conditions during the Great Recession. The best estimates are that currently 30 million Americans, nearly 1 out of every 10 of us, came out of the financial crisis with 1 or more debts in collection for amounts that average about $1,400 per person. While we can put a number on debt, we cannot quantify the emotional toll that it takes on consumers to live under the shadow of indebtedness, especially if they're treated poorly by debt collectors. Such experiences are almost inevitably accompanied by mounting feelings of frustration and helplessness. While many debt collectors play by the rules and treat customers fairly and respectfully, others try to get ahead by flouting the rules. Our job is to root out bad actors and protect consumers against unfair, deceptive, and abusive practices and other legal violations, which damage both consumers and also every debt collector that tries to operate within the law. We recognize that debt collectors represent a wide spectrum of firms. They're an essential part of the credit system. Congress has concluded that much lending should be done on the basis of the borrower's ability to repay, and we underscored this notion with the important qualified mortgage rule we recently adopted. But the principle of lending based on the ability to repay runs in tandem with the broader and accepted notion that people who owe money to others should in fact repay the money they borrowed, and they should feel their obligation and responsibility to do so. In fact, I've served as a debt collector myself in 2 distinct positions in local and state government. When I served as Franklin County Treasurer, I set new records for collection of unpaid delinquent property taxes. As Ohio Attorney General, I was the primary debt collector for the state government, where we also set records for repayment of funds, but I was also charged with enforcing the law against debt collectors that were operating in the state. I came to appreciate how challenging all of this work can be. At the same time, I came to know that debt collection can be done the right way, treating people honestly and with respect for the circumstances in which they may find themselves. I also came to know how hard it is on people when debt collection is done the wrong way. In January, the Consumer Bureau first began to exercise its authority to supervise firms that have more than $10 million in annual receipts from consumer debt collection activities. Our supervision authority extends to about 175 debt collectors and debt buyers, which account for more than 60% of the consumer debt collection industry as measured by annual receipts. And yes, as General Mills mentioned, it is now an industry. Through our examinations, we're now in a position to evaluate whether federal consumer laws are being followed at every stage of the process, from credit origination to debt collection. And through our enforcement authority, we can take action when we see the law being violated. Last month, we held a joint roundtable with our partners at the Federal Trade Commission to gather information and solicit input from a wide range of stakeholders on the integrity of information used in debt collections and in lawsuits against debtors. We often hear about collectors who pursue payments from the wrong consumers or for the wrong amounts. This can happen when information about a debt changes as it gets sold off, and this data may be unrecognizable to the consumer as the debt gets passed down the line. At our joint roundtable, we heard strong consensus about the need for robust national documentation standards and the need to maintain the accuracy of information used to collect debts. We will keep that in mind as we move toward a rulemaking process on debt collection issues. Today, we're announcing other steps in our efforts to ensure accountability in this market and to make sure that all consumers are being treated fairly. We've already learned a great deal about the debt collection marketplace from our ongoing supervision and enforcement work. Based on that work and in support of it, we're issuing 2 bulletins today that warn companies about practices that will receive particular attention. The first bulletin makes clear that certain practices in the collection of consumer financial debts violate the law, regardless of what kind of entity engages in them. Only the conduct of third-party debt collectors and debt buyers is subject to the specific restrictions and prohibitions set out in the federal statute known as the Fair Debt Collection Practices Act. First-party collectors, or those seeking to collect directly on a debt they themselves extended to a consumer, are not generally covered by this statute. Today's bulletin makes clear, however, that these first-party collectors are subject to the general prohibition against unfair, deceptive, or abusive acts or practices in the Dodd-Frank financial reform law, and many of the same kinds of restrictions may be applicable here as well. Some collection methods violate the law because they involve deception. Our bulletin identifies a number of practices that we view as likely to be illegal in this regard. For example, no matter who owns the debt, the person collecting cannot use any false, deceptive, or misleading representation to get a consumer to pay. Debt collectors should not threaten legal action like arrest or prosecution or imprisonment when they do not have the authority to pursue it. They should not falsely represent the amount of the debt that is owed or misrepresent that the consumer's debt could be forgiven. It is also improper to fail to post a customer's on-time payment correctly and then charge them late fees. And intimidation, abusive tactics, or profane language are simply out of line. These are just a few examples of data collection practices that harm consumers. So today's bulletin makes clear that we will be working to ensure that everyone collecting on consumer debts is following the law. This is consistent with our new responsibility to engage in even-handed oversight of entire markets, regardless of whether or not individual participants are chartered institutions like banks or non-chartered institutions like debt collectors and debt buyers. Illegal practices by anyone harm consumers, erode consumer confidence, and undermine fair competition by responsible providers in the financial marketplace. The law clearly recognizes that debt collectors can significantly hurt consumers in ways that go beyond pure dollars and cents. Much of the law was deliberately crafted to protect the dignity and privacy of the individual consumer and to ensure that he or she is treated with the respect we all deserve, even if we've fallen behind on one or more of our financial obligations. Our second bulletin warns companies that they must be especially careful whenever they make statements about how paying a debt will affect a consumer's credit score, credit report, or credit worthiness. Our experience indicates that the debt collection industry would benefit from cautionary counsel on how to have these discussions with consumers. Debt collectors use all sorts of strategies, some legitimate and some illegitimate, to convince consumers to pay their debts. One strategy is to discuss how the unpaid debt affects a person's credit worthiness, and we're concerned that some of these discussions could be illegal. The text of this bulletin highlights some of the potentially deceptive claims that debt collectors may make to consumers about their credit reports and credit scores. Debt collectors know that the information in a credit report can have a powerful influence over a consumer's further access to credit, and they may use this as leverage when talking to consumers. But some debts are too old under federal law to be included on a consumer's credit report for most purposes. Collectors may try to conceal this fact, telling consumers that paying the debt would remove it from their credit report, even though the debt does not show up there anyway. We've also seen other types of cases where debt collectors mislead consumers by telling them that paying a debt would improve their credit score or credit worthiness. The bulletin is intended to serve as a warning that such practices are wrong and that the Consumer Bureau will be attentive to holding people accountable for illegal actions. Today, we're also announcing two ways that we're trying to help consumers help themselves to hold debt collectors accountable under the law. First, the Consumer Bureau will now accept consumer complaints about debt collection, including those referred from Maine, which has long been one of the issues that consumers complain about most frequently at all levels of government. So we will be able to address consumer debt collection complaints and help individual consumers try to reach an appropriate resolution with their collectors. Consumers can submit a complaint against any company that tries to collect a debt from them. But consumers also can do more. They can choose to submit a separate complaint against the company with whom they had the original account. This intake system will be useful as a feedback mechanism for creditors that have hired third-party debt collectors or sold their debts. They will be made aware of the kinds of struggles consumers are having with their continuing debts and can potentially rethink what is happening to their customers or cut off those collectors they deem to be problematic. We have found consistently that consumer complaints provide us with essential insight into the actual experiences of consumers who are navigating the complex financial marketplace. It is through our consumer response function that we're able to have the most direct and immediate impact on the lives of individuals. Once a consumer submits a complaint to us, it is screened and forwarded to the appropriate company. The company reviews the information, communicates with the consumer as needed, and determines what action to take in response. It then reports back to us and to the consumer. We invite the consumer to review the response and provide feedback. We review the feedback using this information along with other information, such as the timeliness of the company's response, to help prioritize complaints for investigation. We already accept complaints on many other consumer financial products and services: mortgages, credit cards, student loans, auto loans, bank accounts, credit reports, and we're pleased now to be able to take debt collection complaints as well. We will learn much from these efforts. The second way we're helping consumers is by publishing 5 different action letters on our website that consumers themselves can use to communicate with a debt collector. This approach reflects our view that self-protection can be an effective form of consumer protection in some situations. Several of the letters are designed to help consumers gain valuable information about the debt being collected. Putting a specific request to a debt collector in writing is often the best way to do this. Other letters help consumers protect themselves from unscrupulous behavior by debt collectors. These action letters are valuable because consumers have rights under the law, but they often do not know what rights they have or how to assert them. For many Americans, self-help is a good starting place in the struggle for dignity and respect. These letters are not a substitute for legal advice or representation that consumers may want to seek as a means of preserving their legal rights, but they're important initial tools that consumers can use to protect themselves. The first action letter is for consumers seeking more information about a debt the collector has told them that they owe. It asks specific questions about the debt and can be used to inform the collector that the consumer is disputing the charges until they have more information. This letter is useful for a consumer who may not immediately recognize the nature or amount of the debt, or who needs to find out more about the debt before deciding whether to pay it. The second letter tells the debt collector to stop contacting the consumer unless the debt collector can show evidence that the consumer is responsible for that particular debt. The letter also makes clear that the consumer is disputing the debt. Consumers who affirmatively believe they have no responsibility to pay the claimed debt may want to send this kind of letter. The third action letter is for consumers who want to restrict when and how a debt collector can contact them. Under the Fair Debt Collection Practices Act, debt collectors are prohibited from contacting a consumer about a debt at a time or place that they know or should know is inconvenient. Until the collector is put on notice, more specific notice of the consumer's individual circumstances, however, much contact might occur that the consumer actually finds harassing. In this letter, the consumer tells the debt collector how they would like to be contacted, which is a useful option for a consumer who wants to work with the collector to resolve a debt. The fourth letter is for consumers who have hired a lawyer. Generally, the debt collector should be directed to contact the lawyer instead of the consumer in this situation. So in this letter, the consumer provides the debt collector with the lawyer's information and puts the collector on notice by specifying that any further contact should be made only with the lawyer from that point forward. The fifth action letter tells the debt collector to stop any and all contact. Under the Fair Debt Collection Practices Act, a collector generally must stop contacting a consumer after it receives a written request to do so. But it's also important for consumers to note that stopping contact from a debt collector does not cancel the debt, and it does not prevent the collector from suing them. For consumers who find that they're being harassed by a collector, this letter can be a valuable option. The point of these action letters is to place debt collection activities on the plane where they belong. They should be business dealings, and they should not become personal in nature. It is simply not true that every consumer contacted by a debt collector is a so-called deadbeat. And even those mired in tough economic situations are entitled to the dignity and respect they deserve as free and equal human beings. Giving someone grief and making their life miserable are familiar but unacceptable debt collecting tactics. Armed with knowledge of their rights and how to pursue them, consumers will be better able to stand up for themselves and defend against such tactics. We ask those in the consumer movement to help us make people aware of these resources that are now available as part of our Ask CFPB page on the Consumer Bureau's website at consumerfinance.gov. The marketplace for the collection of consumer debt remains a very challenging market for consumers. It did not get this way in a hurry, and it will take time to change it in a lasting way. But we will work closely with our partners across the country to achieve that important result. Consumers need to know that they have someone who will stand on their side, and we want to ensure them the dignity of being treated fairly, even in adverse economic conditions. We take these goals to heart, and they will guide our actions. Those debt collectors that are treating consumers fairly have nothing to worry about and should go on about their business. But those using illegal means to collect consumer debts should be forewarned that we will not tolerate such behavior. We will use our supervisory and enforcement authorities to identify and eliminate illegal practices while simultaneously empowering consumers to stand up more effectively for their rights under the law. Promoting honest behavior in the marketplace is in our country's best interest. Both responsible businesses and consumers stand to benefit by enforcing adherence to these basic norms. There is no reason why debt collectors cannot treat consumers with dignity and respect, even as businesses are able fairly to collect the money that is actually due to them. Thank you for joining us here today, and I look forward to vigorous and enlightening discussions. Thank you.
Thank you, Director Cordray. At this time, I'd like to invite staff and distinguished panelists to join the stage. While the panelists take their stage, I want to take a moment to thank those joining by live stream. You can access the web link via Twitter or Facebook. And before we get started with our panel discussion, I'll take just a few moments to show you how you can file a complaint with the CFPB. Consumers will be able to submit their complaints regarding debt collection by clicking on the debt collection icon on consumerfinance.gov or calling our contact center at 855-2372. When submitting a complaint, consumers will tell us the type of debt, the specific issue and sub-issue, their narrative about what happened, and their desired resolution. When consumers submit their case, they will be asked to tell us the name and information of the company that is contacting them about the debt, the name and information of the company that the original account was with. Consumers can choose to submit a separate complaint about each company if there are more than one, using the single complaint. They can also add any documents like their G notice if they received one from the debt collector. Consumers provide their contact information similarly to all other product complaints. On the review and submit page, the consumer can see exactly what information will be sent to the company and edit their information before submitting the complaint. After they submit the complaint, consumers will receive a complaint number for each company that they submitted a complaint for and can track the status of each complaint by logging in at consumerfinance.gov/complaint. Additionally, consumers can find the sample letters that Director Cordray described at consumerfinance.gov/blog/debt collection/ or at Ask CFPB when you have questions. So let's get started with our panel discussion. Deputy Director Antonakis joined the CFPB in November 2010 as the Assistant Director of Large Bank Supervision and was named the Associate Director for Supervision, Enforcement, and Fair Lending in June of 2012. His background includes more than 2 decades as a financial services regulator. In January of this year, he was named as the Acting Deputy Director. Corey Stone is the Assistant Director for the CFPB's Office of Deposits, Cash Collections, and Reporting Markets. His team works across all of the Bureau's divisions to build market intelligence, develop policy options, and coordinate with consumer groups and industry to do outreach in the markets it covers, including debt collections. Corey, you have the floor.
Thank you, Sixta, and thank you and all of your colleagues for organizing this Out of the Beltway event. We know there's a lot that goes into bringing all these people together in places, and these are an important part of our outreach as a Bureau. So it's particularly here to be in, pleasure to be here in this beautiful city in this gorgeous hall. Director Cordray spoke today about a number of different initiatives that the Bureau is taking in the debt collections market, and these are quite varied, and they really reflect the complexity of debt collections. These cut across, or debt collections activity cuts across all of the different kinds of credit in the market. We tend to talk about credit card debt because it is the biggest, has been the biggest category for a while, but the fastest growing categories of debt collections today are student debt and medical debt. And each of those has particular complexities and contexts that we need to pay attention to. There are over 4,000 debt collection companies and many more creditors who are using debt collection agencies to collect debt. And so these represent local players, national players, a vast array of different kinds of organizations and companies of varying levels of sophistication. And we need to pay attention to that and their ability to comply with the law. And there are many different parts of the process. So from initial notice to consumers all the way down to, as a last resort, litigation and all of the things in between, from the telephone calls to the voicemails to the conversations that happen over the phone. Each of those has particular importance in the process and present opportunities for effective collection and also opportunities for harm to consumers. So we use this event, as we used our roundtable last month, as part of being a data-driven agency to learn more about the process and learn more about what consumers are experiencing and how we all at the state and national level can work to make it better. We've assembled distinguished panels today of consumer advocates on my left and industry representatives on my right, and we will be introducing the panelists, each of whom will give 3 minutes of remarks, and then Zixta and Steve and I will be posing questions to them as part of the larger effort today to learn more about what consumers are experiencing and how we can make this system work better. So I'm going to start by introducing our consumer panel on our left. We'll begin with Dalia Jimenez, who is an associate professor of law and the Jeremy Bentham Scholar at the University of Connecticut Law School. We'll then hear from Alexis Ivanishu, a research and policy analyst for the New Economy Project in New York City. And finally, we'll hear from Frank D'Alessandro, who is the Southern Regional Directing Attorney of Pine Tree Legal Assistance here in Portland. Dalia?
Thank you, Corey. It's a pleasure to be here, and I'm very excited both about the announcements that Director Cordray just made with regards to the Bureau's activities in debt collection, as well as really excited to learn about the letters that have just been posted to the CFPB website. And I'm excited because those letters really aim to empower consumers to communicate with debt collectors. And consumers, yes, can communicate with debt collectors now. The problems might be that they may not feel like they have the right language or understand their rights or know what kinds of questions to ask, and these letters go to that. And this is interesting to me because of the larger concern I have about the number of lawsuits and filed in debt collection proceedings, and the number of consumers that actually never show up to answer those lawsuits, which, depending on what study you read, goes between 70 and 90% of consumers who are sued in a debt collection proceeding that don't show up. And so that ends up meaning that for those consumers, a collector can get a default judgment, which in many cases can mean garnishment or a lien on their home if they have one, which is a very serious consequence for consumers. And the question is, why is it that they don't show up? Is it because they don't understand the consequences? Is it because they don't know their rights, or they're intimidated by the process, by the legal system? I actually have a study with Lois Lupica at Maine Law School and Professor Greiner at Harvard Law School, with Pine Tree Legal Assistance as well, that is going to try to find out the answer to that question by giving consumers a sort of empowerment package, giving some consumers an empowerment package with information about how to resolve or how to help themselves in a lawsuit, and giving some an offer of representation by Pine Tree, and seeing whether those things actually make a difference in either the number of consumers who engage with the debt, either by showing up or by contacting the collector, or the results of the lawsuit, the outcome of the lawsuit, or even more importantly, later on, their financial health and well-being. And I think these are important questions to CFPB. There are many, many questions and issues in debt collection, as Corey said, it's a very complex system, and it really does touch on the lives of many, many consumers, 30 million and counting, and I'm very excited that the CFPB is putting a lot of their efforts behind this. Thank you.
Alexis?
Thank you. And thank you to the CFPB and to Director Cordray for having me here today. My name is Alexis Ivanishiu, and I'm a research and policy analyst at New Economy Project, formerly NEDAP. We promote economic justice in low-income communities and communities of color in New York City. And among our activities, we bring impact litigation, and through a legal hotline, we work with low-income New Yorkers to resolve a host of financial justice issues. Our hotline is flooded with calls from people whose lives are being devastated by abusive debt collection lawsuits. People can't pay their rent or can't pay their utility bills because collectors have frozen their bank accounts or are garnishing their wages. And because of too often fraudulent debt collection judgments that appear on credit reports, people are unable to find housing or even jobs as more and more employers are checking people's credit. I'm going to focus today on two major debt collection issues we see in New York. First, the prevalence of abusive debt collection lawsuits, particularly filed against people living in communities of color. And second, the large banks' role in facilitating abusive debt collection tactics. We just released a report called The Debt Collection Racket in New York. That report shines a light on abusive debt collection lawsuits filed by collectors that routinely obtained default judgments from the courts, even though they almost always failed to present evidence of the debt as the law requires. These abuses stem largely from structural problems related to the buying and selling of old charged-off debts. We also found that New York's communities of color have disproportionately borne the brunt of these abusive debt collection lawsuits. Communities of color make up all 10 of the New York zip codes with the highest concentrations of default judgments and debt collection lawsuits. These are the very communities that banks redlined for decades, that have been at the epicenter of the predatory lending and foreclosure crises. These abusive debt collection practices are directly linked to broader economic discrimination and wealth inequality. Another problematic debt collection issue we've seen relates to banks that illegally facilitate and profit from payday lenders' abusive collection tactics. Some internet payday lenders make loans in New York illegally, and as the CFPB has documented, payday loans trap people in an inescapable cycle of debt. We've seen that when borrowers request that banks stop payday lenders' illegal debits, which they have the right to do under federal law, the bank often refuses and then charges overdraft fees when there isn't enough money to cover the payday lender's attempted debits. In the case of our client, Ms. B, payday lenders attempted to debit her bank account 55 times over the course of 2 months, and her bank, one of the country's largest, charged her more than $1,500 in overdraft fees. The bank then proceeded to harass her to pay the overdraft and negatively reported her to check systems, which prevented her from opening a new checking account at another bank. We sued the bank over these illegal practices, and I'm pleased to report that we reached a groundbreaking settlement with them, and the bank has committed to revamp its systems and procedures to ensure that it now properly stops payments upon customers' request. Our organization has worked on debt collection abuses for years as a matter of racial justice and neighborhood equity. We look forward to the CFPB using its authority to create meaningful standards for bank sale of charged-off debt, to address rampant robo-signing abuses and other violations of law that I've described today. Thank you.
Thank you. Frank?
Thank you. I'd like to thank the CFPB for getting outside the Beltway today and being in Portland and permitting our participation in this field hearing. When Pine Tree Legal Assistance first opened its doors nearly 50 years ago, one of its first major court victories involved a challenge to the long-standing debt collection practice in Maine that permitted judgment creditors to imprison Maine debtors until a judgment was satisfied. Since the recent economic collapse precipitated by underregulated financial markets, Pine Tree has intensified its work in the area of consumer rights, first with the defense of homeowners in foreclosure actions, and more recently with the representation of consumers against third-party debt collectors. Our recent experience in both foreclosure and credit card debt collection cases has been remarkably similar. In both instances, we encountered a system dominated by mortgage servicers and debt collectors who were able to obtain court judgments with very questionable evidence. We encountered homeowners and consumers that were terrified that non-payment of a mortgage or credit card debt would result in their incarceration. And we encountered stiff resistance from many quarters to the notion that attorneys should even appear in court and vigorously advocate for a homeowner behind in their mortgage payment or a family who might be over their head in credit card debt. We have learned two things from our experience. The first is that legal representation makes a dramatic difference in the outcomes for homeowners and consumers. And second, additional legal protections are desperately needed to fully address consumer interests. The vast majority of cases brought by debt buyers in Maine courts result in a default judgment. We also routinely observe cases in which people agree to make payments that they cannot afford from income that is exempt from collection, such as disability or retirement benefits. This is wrong. It's against the law, and we need to do better. In order to remedy the problems that we have repeatedly observed, at a minimum, the following 4 steps should be taken. First, every communication from a debt buyer or debt collector with a consumer should be in plain English and explain the steps a consumer needs to take to avoid a default judgment or another loss of their rights, and describe the types of income that a consumer may have that are exempt from collection. Second, debt collectors should be prevented from taking any action to convince a consumer to make payments on a debt that is time-barred or otherwise uncollectible at law. Third, subsequent debt buyers need to be held responsible for the acts of previous debt collectors. And finally, a private right of action must be provided to all consumers so they have the power to bring a case on their own behalf to make sure that legal protections are enforced. That's it.
Great. Thank you, Frank, and thanks to all of our consumer advocate panelists. I'll now introduce our industry representatives. First, we will hear from Joanne Needleman, who is President-elect of the National Association of Retail Collection Attorneys. And after Joanne, we'll hear from Patrick Morris, who is the CEO of ACA International, the largest trade association of debt collectors. Joanne?
Thank you, Corey, and thank you, Steve, and thank you, Director Cordray, and the whole CFPB staff for inviting me to participate in today's field hearing. Portland is my second favorite city. I was coming here anyway, and thank you very much for allowing me to do that a day early. And it's an honor to be here, and thank you to the participants in the audience today for coming. My name is Joanne Needleman, and I'm an attorney and vice president of the law firm of Maurice & Needleman, which is located in both Pennsylvania and New Jersey. My firm represents clients in the consumer financial services industry, and we litigate extensively in matters involving the Fair Debt Collection Practices Act, which you will hear today being referenced as this FDCPA, and the Fair Credit Reporting Act, which we will talk about in terms of FCRA. I've been a collection attorney for 17 years. And additionally, as Corey indicated, I am the president-elect of the National Association of Retail Collection Attorneys, also known as NARCA. NARCA is a trade association comprised of over 700 debt collection law firms committed to the fair and ethical treatment of all participants in the debt collection process. Our members are required to adhere to NARCA's Code of Professional Conduct and Ethics, and as attorneys, we are required to practice law in a manner consistent with our responsibilities as officers of the court. As attorneys, we must also adhere to applicable state and federal laws, rules of civil procedure, state bar licensing and certification requirements, and rules of professional conduct for our particular states in which we practice. The CFPB's recent bulletin regarding the prohibition of unfair, deceptive, abusive acts or practices, as we will probably call as UDAP today, in the collection of consumer debt identifies these same prohibitive acts as are already identified in the FDCPA. Debt collectors who engage in UDAP, as well as those who intentionally ignore and violate the FDCPA, is unacceptable. Ultimately, this harms consumers by creating communication barriers between legitimate debt collectors and consumers who legitimately want to resolve their debts. NARCA concurs with the CFPB that consumers must be treated fairly and with respect, and NARCA supports measures that will help consumers distinguish professional, responsible, and ethical collectors from those who are not. NARCA appreciates the CFPB's collaborative approach to finding solutions to the issues facing consumers. Over the past several years, representatives of NARCA have met with representatives of the CFPB personally to discuss these issues. The CFPB has always provided an open ear and a forum for thoughtful discussion and the exchange of ideas and viewpoints. I was very pleased to participate in last month's CFPB-FTC roundtable discussion, which helped identify issues and possible solutions regarding debt collection data. NARCA was also very appreciative for the opportunity to offer its input on the design of the CFPB's debt collection complaint portal, which you saw on the slides this morning. The CFPB was very gracious in allowing its representatives to present a webinar to all NARCA members on the complaint process, and NARCA had the opportunity to encourage its members to register their contact information with the CFPB. Through this interaction, NARCA has developed a better understanding of the CFPB's initiatives and deep commitment to consumers. Likewise, I believe the CFPB has come to understand the viewpoints and concerns of NARCA's members, which also demonstrates a commitment to consumer protection and fair and reasonable regulation. Expanding on the open line of communication NARCA has enjoyed with the CFPB, it is also critically important that consumers communicate and participate as well, not with just the CFPB or state regulators, but also with the people who are attempting to collect your debt. Communication is the single most critical action that can lead to resolution of issues. If you receive a letter or call from a collection attorney, respond. Open a dialogue, ask questions, be specific. If you dispute a debt, let us know what it is that you dispute. Remember that communication is a two-way street. While the CFPB has provided you with some sample letters that may be helpful in some circumstances, the idea is not to communicate in order to build barriers, but to communicate in order to achieve a resolution. NARCA has also developed tips for consumers in responding to a collection attorney, and it is on our website at narca.org. Finally, if you receive a summons to appear in court, please appear. I know the court process seems intimidating, but it is designed to provide a level playing field that treats all parties equally. It does this in two ways. First, as collection attorneys, we are bound by our ethical rules of professional conduct and state bar rules to treat consumers, to communicate with consumers in certain ways, especially when they don't have attorneys. And second, inside the courtroom, you have a completely impartial, unbiased judge, who is the ultimate finder of fact. This is your opportunity to explain your side of things, and it is important that you be heard. Today's hearing epitomizes the CFPB's collaborative approach with the participation of industry and advocacy panelists, and most importantly, the consumers in this audience. I particularly want to thank them for taking the time out of their busy day to attend today's hearing. Thank you.
Thank you. Thanks, Joanne. Pat?
Thank you, Corey. The ACA is pleased to participate and appreciates our ongoing work with the CFPB to help the Bureau better understand our industry and help our members better understand the Bureau. To give you a little context, ACA International is the largest trade association in the world for debt collection. We have about 5,000 members worldwide. We've worked with the CFPB from the outset on its creation of the consumer complaint resolution process for debt collection that the director mentioned earlier. ACA has helped provide insights and feedback from our membership on important aspects unique to consumer debt collection that the CFPB should be considering as it created this complaint resolution process. Last month, similar to what NARCA did, we jointly hosted a teleseminar to help ACA members learn about the details of this new process, which was immensely valuable to our members, and there was high participation, and we thank the Bureau for providing the speakers for that as well. CFPB continues to work with ACA to get member questions about the complaint resolution portal answered from that seminar,
and ACA continues to encourage its members to sign up to the Complaint Resolution Company portal, and many ACA members have participated in the training that's been held by the CFPB. The last count I heard in the last couple of days was over 600 or so of our agencies have already signed up. Now, while some might want to paint with a broad brush, and I don't want to quibble with your seating arrangements, Corey, but you know, our view is that debt collectors are not the enemy of consumers. Our members take collection laws and consumer complaints seriously and want to resolve them and deal with consumers every day in a respectful and professional manner. We believe that consumers are best served when they have the opportunity to communicate and resolve their complaints, as was mentioned earlier. Communication between a consumer and a debt collector is absolutely critical, and without that communication, we can't resolve the reason for the contact, we can't identify a wrong party contact, and importantly, without communication, we can't address and resolve consumer complaints. We're heartened by the CFPB's recent report outlining a reduction in consumer complaints against debt collectors, but know there is much more work to be done to continue to reduce complaints from ever occurring and resolving existing complaints. Based on the Council of the Better Business Bureau's annual report on inquiries and complaint statistics, we've repeatedly shown that when given the opportunity to communicate with the consumers, we can be successful at accomplishing this feat. U.S. collection agencies resolved 86% of the consumer complaints received in 2012, exceeding the national average of 77% for all industries. In society, debt collectors and others are publicly measured by the raw numbers of complaints received. It garners significant media attention and is often used as a benchmark of industry performance. Yet often there is also little context to these consumer complaints. It's imperative to point out that just because a consumer has complained to the CFPB does not mean or imply that the debt collector has actually violated the law or engaged in wrongdoing of any kind. Each year, creditors and debt collectors make more than 1 billion contacts to consumers, and the number of complaints is relatively small in comparison. We need to keep this in mind before castigating debt collectors or connecting complaints automatically to bad behavior. Our members believe consumers have important rights under federal and state law and deserve to be treated fairly, respectfully, and free of deception and abuse. It is a hallmark of our training, and ACA will continue and encourage active communication between consumers, consumer groups, and third-party debt collectors, in addition to working with the CFPB to provide feedback that refines the resolution process to ensure that it accurately reflects the environment of consumer debt collection. Thank you for having me.
Thank you, Pat, and thank you, Joanne and Dahlia, Alexis, and Frank. We'll now begin our questions with Acting Deputy Director Antonikis.
Great, thank you, Corey. Good afternoon and welcome, everyone. Like everyone else, I'm especially pleased to be at this Outside the Beltway hearing, especially pleased because it's an opportunity for me to come home to New England. I want to welcome all of our panelists here today, and Patrick, for being patient and for being the last to speak. You have the benefit of getting the first question. So Director Cordray announced earlier today that we will start taking complaints on debt collection, and you also referenced some of the efforts of your members to become ready for this process, and just would ask you to speak a little bit more so about how your members feel about having complaints taken on debt collection practices by the Bureau.
Thank you. Thank you for letting me go first again, or last first. We've worked with regulators at the state level, certainly at the federal level, on matters pertaining to industry oversight since the association was formed in 1939. So, you know, our members, I think, are very familiar with the laws and the regulations governing their work. As I mentioned earlier, we do extensive training through the association and at all the agencies that I've visited to make sure that members are familiar with that. Our members have welcomed the development of the complaint portal. Our members, I believe, are ready for it. They most have already robust internal compliance departments. And as I'd mentioned earlier, as we had put the word out that you all were starting to ask for the contact at the agency, there was a quick response. Our agencies want to get these complaints resolved and want to make sure that you all have the person to talk to get them resolved timely.
Great, thank you.
I want to add my thanks to the panelists as well. We learn a great deal from these conversations and are grateful that you're willing to engage in conversation with us. This question is for Professor Jimenez. Professor Jimenez, can you describe what you see as some of the benefits and potential challenges as well to having the CFPB take debt collection complaints from consumers?
Absolutely. I think, well, I'll start with the benefits because I think there are many and they're very exciting, actually. One is just the availability of information for the Bureau and other regulators where the problems might be, both physically where they might be around the country, as well as what kinds of collectors, whether it's a particular type of debt being collected or a particular size or company that is collecting and any problems associated with that. So a sort of heat map, if you will, I think that is invaluable to determine where to focus efforts, limited resources in terms of enforcement and other investigations. The other one is that all of that information, if the Bureau continues to do what it's been doing in the past, will be public at some level for the rest of the country to search and to look at and to see whether their state or their area is particularly hard hit by these types of complaints or others, and to use that in their, whether it's an attorney general or others as they're pursuing cases or trying to resolve some of these issues. The fact that beginning with this system, unlike the FTC, we will be able to, the CFPB will actually do some investigation of the complaints if it thinks it's warranted. We'll actually resolve them in a sense of, yes, there is some violation of law here, or there isn't. Not all, but the ones that, with its limited resources, it can get to. We will actually have some more detailed information about what really is going on. Are consumers complaining about things that aren't violation of law, but they just perceive as inconvenient, or they think they might be violations of law, or are there really true violations going on here? And that sort of gets me to the downside or the potential pitfalls here, and that is if the volume that the FTC was seeing plays out with the CFPB or anything close to that, it will be, I think, very difficult, given the staff the CFPB has, to really pay as much attention to those complaints as it wants and as it has with other kinds of services. So I think that is the challenge, and the balance here. But I'm very hopeful. And thank you. Thank you.
I have a question for Joanne, and this relates to the bulletin Director Cordray announced today related to communications about credit reports and credit scores. How feasible is it for a collector, or for that matter, a collections attorney, to know that a debt is or isn't obsolete for credit reporting purposes?
Thank you for that question. The answer is it depends. I hate to give you that answer, typical lawyer answer, but sometimes it's not feasible. And again, it comes back to issues of information. The FCRA says that you can't report a debt that is 7 years past default. And sometimes default, does that mean charge-off? Does that mean last date of payment? So we have to define what that is. Sometimes there's information where we don't know, maybe there was a payment, so maybe that could extend the time. So it can be difficult, but I can tell you from my perspective, in dealing with members who are collection attorneys, that is not an issue that we run into because most of our members don't credit report. To the extent that our members do any pre-litigation activity and have communications with consumers, yes, that is an issue. I think that I know that there's training on that issue, but it's not, I think that's something really more that Patrick can talk about, because I think that many of his members are involved in more credit reporting just based on agencies and working with creditors, more so than my member law firms. But I think your question raises some issues, and again, that goes back to what we were talking about last month. It's the information of data integrity. How do we know, how do we get the proper information to know what is the default, and how does that information travel?
Right. And thank you for pointing out the ambiguity of when the clock starts. It is, I think, under the FCRA, the date of first delinquency rather than default, which has its own definitional issues. But Pat, do you want to, do you have anything to add?
Yeah, let me just start by saying I'm not an attorney and I'm not going to fake it with this question, but yeah, I just think kind of an important point to bring forward is look, the debt collector's work in the third-party world relies on the data provided by the creditor, and a bunch of folks have already referenced the roundtable that a lot of us participated in last month with you all and the FTC. You know, and this includes account details, documentation, information about the consumer believed to have incurred the debt. So certainly, I think the information provided by the creditor is going to be pivotal to what most third-party collection agencies then have and can do.
Thanks. Great. So my next question is for Alexis. Alexis, as you know, certainly credit scores are comprised of many variables, many of which are interrelated. With that in mind, is it possible that a creditor could reliably tell a consumer that taking a certain action would have a direct impact on their credit score?
So as we see on our hotline, and we hear from callers to our hotline, we do have a legal hotline, it is absolutely the case that debt collectors will tell people that paying a debt will have a certain effect on their credit score, even when the collector may not be able to be reliably sure that that is the case, or may not be reporting to credit bureaus. And so the CFPB's action today, issuing the bulletin, reining in that abusive practice, is really important. And I'd just like to say one thing about why this tactic works for collectors also. It's because people are so concerned about their credit and how it determines their access to jobs, to housing, insurance, and of course loans as well. And the credit bureaus, the private companies that aggregate this information, have really stepped up their marketing. And this expanding use of credit information has a discriminatory impact on lower income people, on people of color who are too often targeted for predatory financial products.
Great. Thank you, Alexis.
This next question is for Pat. Pat, can you talk a little bit about standard procedures in creditor operations? For example, is it a standard procedure in creditor operations to do business in a manner that might be considered an FDCPA or other violation if the creditor were also a debt collector?
Well, again, the majority of our members are third-party debt collectors and collection attorneys and not creditors. But based on what we know from our creditor members, most of the large creditors already conform to the internal collections process, to the spirit of the FDCPA, for a lot of reasons. The least of which is, I think most of the attorneys here will know, the FTC already has the ability to consider non-conforming practices to be unfair or a deceptive trade practice under Section 5 of the FTC Act.
Thank you.
Great. So I have a question for Frank, and this is maybe a great one for consumers. How can a consumer ensure that someone who may be calling them about a debt has a legitimate right to contact them and collect from them?
Well, that can be a difficult question to answer. Under the Fair Debt Collection Practices Act, the debt collector is supposed to provide information validating the debt to the consumer within 5 days of the initial communication with the consumer. The problem is when that doesn't happen and a consumer is not aware of their rights, there are other protections in the statute. The consumer can request that information if they request it from the debt collector within 30 days of the contact. Many consumers are not aware of that, And many debt collectors, if you go outside that 30-day period, will refuse to provide the information. So it's a difficult issue. It's really important. I mean, we have seen cases in where a consumer, multiple parties try to collect the same debt from the consumer. And so it's important that the consumer be able to verify that the person contacting them actually has the right to enforce the debt. And it's not just, it's not just for show to make them prove that. It's a really important thing that before someone makes a payment on a debt, that they're assured that the person they're making the payment to is the one to whom they may owe the money.
Thank you.
So wonderful. So I will begin the lightning round. I will have one question that I'll ask of all the panelists. I'll ask for the consumer representatives to respond first and then the industry representatives to follow. And the question is this: if you were advising a consumer who wanted to resolve a debt, what is the one thing that you would recommend that they would do, and what is also something that you would tell them to be cautious about? So just one more time, since I'm going to ask everyone to respond. Advising a consumer who wants to resolve a debt, what would you recommend that they do, and what would you recommend that they be cautious about? Dahlia, we can start with you if you'd like.
Okay, well, I guess it depends on where, the stage at which the debt is at, but let's pretend that it's early on and they've just gotten a letter or a call. I mean, the question Corey just asked is critical. Make sure that this is the party that if you do believe you owe this debt, that you should be paying. And, get that. The letters that the CFPB has just put on their website actually would help with that, at the very least, to get the consumer to say the right words and to feel like they have confidence to do that, to request information that would validate or verify that this is the right creditor, and be cautious both of that and of the amount that you're being asked to pay. Even if you believe, yes, I did have such a debt and I didn't actually pay it, make sure you get verification that the amount you're paying is, the correct amount.
Thank you. Greg?
I think it would be, to add to that, it would be helpful to get some legal help, to consult the CFPB website, to consult like Pine Tree Legal Assistance website, to speak to an attorney, and not just assume that just because someone has contacted you that you owe the debt, especially if you don't feel like you owe the debt. If you feel like it's the wrong amount, you feel like you never had the credit card in the first place, or you've never heard of this person or this debt collection agency who's contacting you and trying to collect the money, it's within your rights, and there's nothing wrong about requesting the information you need from the debt collector for them to show you that they, in fact, own this debt that they're trying to collect.
Yes, I would echo what's already been said, especially about seeking free legal assistance or free financial counseling if it's available. And I would also just point out that a lot of the debt that we see that's charged off by banks is debt that they've sold for pennies on the dollar with very little documentation. So the banks aren't held accountable for that debt, and the collectors who are trying to collect on that debt are doing so with very limited information and sometimes don't have sufficient proof, and therefore rely on robo-signing and other abusive tactics when bringing lawsuits. So people should just be aware that that's going on as well.
Okay, anything you'd want to add about anything consumers should be particularly cautious about in addition to making sure they take the steps to verify that the debt is correct?
Just also being aware of their rights around exempt income, that Social Security, unemployment, many sources of income are protected from debt collection. And people should also think about prioritizing debts and making sure they don't agree to settlement agreements that will not allow them to pay their rent, pay their bills, put food on the table, and they should prioritize those things above.
Great, thank you. Patrick?
Yeah, as was mentioned in the director's remarks, you have to communicate. Avoiding the letter or not taking the call won't make that debt disappear. And by communicating and talking to the collection agency, you can pay the debt, you can verify the debt, you can confirm whether or not they've reached the right person. And of course, as has been mentioned, it gives you the ability to notify the agency if you dispute it, which then, by law, the collector must inform you of your rights.
Great, thank you. Jordan?
Thank you, Steve. Your question raises a good point, especially from the perspective of my members as attorneys. It's hard for us to advise consumers because we represent a client. So we have to be very, very careful, and a question like that really IDs the conflict that attorneys have in the debt collection space, is that we have a professional obligation to properly and zealously represent our clients, but at the same time, we have to give tremendous deference to consumers, especially if they are not represented. So I'm happy to say that I agree with some of the points that the consumer side is making. I do agree that if you have free legal services available to you and you're discussing the settlement of debt, absolutely go seek those services. I think that they could provide some excellent counseling. And I also agree that when a consumer is confident that this is their debt and this is their obligation and they want to pay it, and we have this on our tips on our website, only agree to what you can afford. Do not enter into an agreement that you can't afford. That's not going to resolve the issue. So again, the prioritization, the understanding of what your priorities are, your rent or whatever. After that, really look at what you have and make a settlement. And you would be pleasantly surprised that even a small commitment a month, even if it's small, would be acceptable to the majority of responsible and ethical debt collectors.
Great, thank you.
Great. Thank you to our panelists, Joanne Needleman, Patrick Morris, Dalia Jimenez, Frank D'Alessandro, and Alexis Ivanishu. This concludes the panel portion of our public hearing, and we ask our panelists to accept applause from the audience and leave the stage. As they're leaving the stage, and before we start with the audience portion, there were 2 points came up in the discussion I just want to emphasize. The first point is why it's very important, as was noted, for a consumer to actually communicate with the collector. And that's because there is a certain amount of communication that occurs that is completely illegitimate. It is not an actual debt collector. It is somebody who is a fraudster or a scammer imitating or mimicking a debt collector. Around every financial services industry or practice that we have seen, there's a fringe element of scams and frauds that exists. It happens with mortgage servicing, it happens with debt collection, where people will simply be communicating with completely phony things just to see what kind of money they can get. So that's another reason to, and both legitimate debt collection companies and consumers are victimized by that practice that pollutes otherwise normal communication. The second point is one that I really didn't cover adequately in my remarks when I talked about our consumer complaint database. Not only is it a method of resolving complaints, but it also is, we've done something somewhat unusual, which is not unprecedented in the federal government. But we've opened up our database to be accessible to the public. So once we go live with debt collection complaints, and there's a bit of a lag, maybe a 30-day lag as we go through the process and resolve individual complaints, they will be logged into the system, and you will be able to help yourself to take a look at what kind of complaints are being registered there, which ones are coming from Maine, which ones involve which companies. And the point of that is not only, as I said, are complaints very useful to us in doing our work, but we think that accordingly they probably will be very useful to consumers, and we have heard that that is so, and to companies to know what's going on, know what their competitors are doing. And so we do invite you to make use of the consumer complaint database, not only about debt collection complaints, but all the others that we take that may be helpful to you if you're consumer advocates at working with and advocating for consumers as public officials and as industry as you're trying to understand what's happening and how you compare. Maybe you compare favorably with your competitors in terms of your responsiveness and your speed. And if so, you should feel free to brag about that. That's a good thing.
Great. Now it's time to hear from audience participants here today. Our audience includes community leaders, advocates, industry representatives, and of course, consumers. The open mic portion of today's field hearing is an opportunity for the CFPB to hear from you directly, to get your perspective on today's discussion on debt collection, but also to hear from other consumer finance trends and practices in your community and in Maine. Each person will have about 2 minutes for comments, and what we hear from you is invaluable. It is part of how we take in new, fresh information. We want to hear from as many of you as possible, so I encourage you to please observe the time limit so that as many folks as signed up to share their observations have the opportunity to do so. So with that, let's get started with State Representative Jane Pringle. Representative Pringle, you'll soon get a mic.
Thank you very much. I'm here more to listen and learn, although one of my questions relates to the responsibility of the lender in the first place of making sure that the person they're loaning money to can pay it back. It seems to me, watching the financial crisis, I kept wondering how people were able to buy these homes. I knew how much I made and how much I could afford to borrow, and it seemed like loans were being made in astronomical amounts to people who didn't have income or assets. So we didn't hear about that. Is there any effort to look into that or improve, or is that part of Dodd-Frank and not related to what you're doing here today?
Thank you. You just threw a softball question at us. We have spent the first couple of years at the Bureau engaging in mortgage market rulemaking, specifically around Title 14, that creates ability to repay requirements designed to get both generally and specifically at precisely that issue. You're right. In the run-up to the crisis, loans were made without regard to ability to repay in many instances. Dodd-Frank Act did address that, and we hope that we have created the kind of framework that will encourage responsible lending attuned to ability to pay and make it a little tougher for the dishonest originators that led up to the crisis. Thank you. Laura Bucksbaum.
I signed up last and get to speak second. This is great. Thank you so much, Director Cordray, and all of the CFPB staff for coming here to Maine. This is just wonderful to have you here and telling us what you're up to and listening to consumers and others from Maine. I work for Coastal Enterprises Incorporated, CEI. We're a nonprofit community development financial institution based in Wiscasset, Maine, and we're also, we are a HUD-approved housing counseling agency. So my experience and comments have more to do with mortgage lending and foreclosure prevention than with debt collection per se, although obviously they're related. I wanted to comment on two things. One is that I understand that the CFPB has recently instituted a consumer financial civil penalty fund, and that I've missed the deadline for your comment period, but I wanted to say thank you for doing that. I think it's a great idea, and to reinforce the comments that I believe you received from the National Housing Resource Center. This is a fund to help recompense to be held for victims, but if victims can't be found, then the funds will go into a pool that can be used for financial literacy and consumer education, as I understand it. And I wanted to urge you to also to create as large a pool as possible and to include one-on-one counseling in the allowable activities that you would fund, to include HUD counseling agencies like mine as eligible recipients, and to think about a range of organizations that could be recipients, including a hard-to-reach population, the ones that serve hard-to-reach populations, limited English proficiency, and rural. We serve a rural population here, and that's really important. So I also wanted to say that I appreciate the new rules that I saw on your website that will require counseling for high-cost loans. I think that's going to be in force in January of 2014. I'd like to ask you to do what you can. I don't know what is within your powers to do, but to work with HUD and others to find ways to incentivize, support, and even require housing counseling for other borrowers that may be putting down low down payments, or that may have less than perfect credit, and maybe others, because our experience is that consumers who receive either homebuyer education or one-on-one counseling or both become responsible homebuyers, don't fall into some of the traps of predatory lenders, and not just predatory lenders, but just don't fall into traps of borrowing more than they can afford, understand being responsible homebuyers. So those are my 2 comments. Thank you very much.
Thank you, Ms. Buxbaum, and thank you for the work that housing counselors do around the country. It's very important work. It's frontline work. We know how difficult it is, but it is of great benefit to the consumers that you serve. We received the comments from the National Housing Resource Center. We meet with them frequently, and they have been an invaluable source of important information as we have worked toward putting together the Civil Penalty Fund. And we will certainly take your views and suggestions into consideration in that process. Thank you. Steve Parker.
Good afternoon. Thank you. And thank for all the panelists and you for coming. My name's Steve Parker. I'm an attorney, collection attorney with Daggett and Parker. I'm a member of NARCA as well. NARCA was represented on the board, on the panel rather. Just wanted to make 2 brief statements. One, that of course, that was said, the number of complaints clearly doesn't necessarily, that's the number of problems. In nearly 25 years of being a collection attorney, I've had several complaints with, in fact, Will Lund's office. They've always been resolved, and they've not been because there's been a problem that something has been done wrong. It's because someone didn't understand the process. For example, someone had a court order for a payment. Their paycheck was garnished, and they thought this was a terrible thing to do. But they just didn't understand the process. So not all complaints, of course, equal a problem, equal something that someone has done wrong. Very often it's something that people don't understand the process. Also, I believe it was Director Cordray had made a comment that it shouldn't ever be personal. I actually disagree. It should always be personal. Every collector, when they are doing the collections, should know the information from the debtor, what's going on in their life, especially when they're dealing with the debtor, working on a collection. Everything that debtor's going through is personal to them, and it's important to what can be done with the situation, how it can be resolved. An awful lot of debt cases cannot be resolved. People don't have the money. Doesn't mean it's not owed, they just don't have the money, so it can't be resolved. But all those things are very personal. So it's really always personal. It certainly shouldn't ever get out of line, and the FDPCA, clearly should always be followed. The very last thing is that there was another comment, excuse me, said those collectors who are treating the consumers fairly have nothing to worry about. And unfortunately, especially with attorneys, that's not always the case. There is a small group of people who are disguised as consumer advocates, and we're not talking about the Frank D'Alessandros and the Will Lunds of the world. We're talking about people who set up practices, who go after very minor technical violations of the FDPCA, which is really something to be concerned about, because what it does is it pushes a large number of collection matters into litigation where it doesn't need to be. Thank you.
Thank you, Mr. Parker. You make some fair points, and we certainly take them into consideration and appreciate your participation today. Renee Dillard. Diane Cipollone.
I am Diane Cipollone, the Director of Training at the National Fair Housing Alliance, known as NAFA, which is headquartered in Washington, D.C. NAFA is also a member of a large consortium of consumer advocates known as the Americans for Financial Reform. On behalf of NAFA, I would certainly like to applaud the Bureau for the announcement today that you will be using your rulemaking authority under UDAP to close an enormous loophole in the Fair Debt Collections Practices Act. That is, that it does not apply to the original creditor collecting his own or her own debts. In your opening remarks, Dr. Cordray, you stated that your new rulemaking under UDAP you will be addressing the issue of the integrity of the information and the data relied upon by creditors. This recommendation, we're very glad to hear this because this recommendation was also in a letter recently to you of May 17th from AFR, also urging the Bureau to use its authority to make sure that all collectors have correct and accurate information on the particular debt. Requiring that data and information travel from one collector to another if the original collector is unsuccessful and the debt is closed would be a very, very strong consumer protection akin to mortgage loan servicing, where one servicer then transfers, the servicing is transferred, all the information travels, and the homeowner, the debtor in this case, would understand, well, who are you now? I've never heard of you. So that if all of the information required to be tracked, and as between the buyers of these debts, then that would go to the issue of who does this debtor think is now collecting the debt? Is there some chain of authority so that the person contacting them, the debtor can rely on and say, yes, you are the person I should be dealing with? Thank you.
Thank you, Ms. Cipollone. Jim Devine.
Hello, my name is Jim Devine. I'm an advocate with Homeless Voices for Justice out of Preble Street Resource Center, and I also have a consumer seat on the board of directors of Pine Tree Legal. And, you know, I would like to express my appreciation first and foremost to the City of Portland to honor their commitment to provide emergency shelter to everyone who needs it, which the numbers is getting greater and greater, and the overflow is going into the overflow, and it's a distressing situation. And I meet a lot of people, and people are there for a variety of reasons. I know of one individual, an older person from upstate Maine who lost his farm because of foreclosure. You know, and a variety of people are in a number of debt issues, and they're there for a variety of reasons. You know, I think I really appreciate this forum here, coming here, CFPB, and all they do. And I appreciate what Pine Tree Legal does. I know that Pine Tree Legal, because of resource problems, can only help about 20% of the people that ask for help. So as far as the solution to this is concerned, from my perspective, and doing the outreach that I do, I think the more education that can be done to people, to consumers, so that they know their rights, where they stand, what they can do about their problems, so they don't just throw up their hands and go occupy the shelter. You know, any hints or clues or opportunities to put the good word out, people have their rights, would be much appreciated. So thanks for the time.
Thank you, Mr. Devine. Thank you for your comments and for the work that you do to help people. Lynn Bromley.
Hi, I'm Lynn Bromley. I'm the regional advocate for the SBA's Office of Advocacy, and just want to say thank you for being here today. Just a couple of quick things. One is, we all know lots of small businesses use their credit cards to finance what they do, so the debt collection issues have a huge impact on that economic drag. I want you to pay attention to that. And also, when the net gets cast and people get pulled into the net, you talked about the difficulty in protecting consumers, but also acknowledging that the vast majority of the business practices are sound, that where that net has gotten too wide, I hope you'll hear from some of the people here today to let you know that, because that also has a big drag on the economy. So I'll defer the rest of my 2 minutes to a consumer maybe that has had a bad debt collection experience, and hope that you get to hear that. Thanks.
Thank you, Ms. Bromley. Claude Morgan.
Hi, thank you. I want to thank the panel. Very instructive afternoon and interesting information. I will just say that if we're talking about a dispute process between the debtor and a collector. There is a model that exists right now for folks to dispute their credit reports and information in the credit reports, and that's through the eOscar system. That allows an electronic portal for both the consumer and the lender to clarify and to make accurate information. And it seems to me that you might take a peek at that model, that it may be ready-made for this dispute process that you're talking about. It certainly keeps the clock ticking, and it keeps folks responsible.
Thank you, Mr. Morgan. Carol McCracken. Anthony Armstrong.
Thank you very much. Thanks. My name is Tony Armstrong. I'm the chairman of the Legislative Committee for the Maine Association of Mortgage Professionals. I've been involved in the board of directors of that association, its predecessor organization, the MBA of Maine, for over 25 years. And I've been in the mortgage banking industry in Maine for about the same amount of time. I own a Maine Home Mortgage Corporation, which is a small mortgage lender resident here in Portland, and serves the entire state of Maine. I also am an attorney, so I guess I would say that I've probably taken a little more interest in the debt collection process, both on behalf of my customers and as a public policy matter, than maybe some people might, because I tend to get into the weeds a little bit, along with some of my friends in the legal community. I had some prepared remarks here, considerable prepared remarks, but I'm going to just kind of skip over that. But first of all, I'd like to thank you very, very much for coming to Maine. It really is an opportunity for Northern New England to speak directly to the folks at CFPB, and we really do appreciate it. Secondly, we really appreciate the fact that you're focusing on this very important area to the mortgage banking industry and to consumers. What we find is that the people in my organization who I've talked to about these issues, we tend not to be so focused on the debt collector and how he treats the consumer on the front end, or the contact and the days of response and all that. What we find where the rubber meets the road is when someone applies for a loan, and unbeknownst to them, their credit score comes in lower than they expect, and they either can't get the loan or get involved in a process that I'll explain in a minute. That's where we get involved. So our focus is kind of interacting and helping the consumer interact with the debt collector midstream, so to speak. And oftentimes I find that the system is set up so that basically the debt collectors, particularly on small debts, won't be harassing or calling the consumer. They just sit and wait till they apply for a loan, and then the consumer comes to them. That's sort of the automatic aspect of all this. So what's happened in our situations with my fellow associates in the mortgage banking industry and in the banking industry, which is also has members in our organization along with credit unions, is that we're dealing at that stage of the game with FICO scores, and what happened and why is the FICO score lower, and how did this all happen? And what I want to do for a second is digress and make it very clear to people how things have changed in the last 2 years with FICO scores when it comes to mortgages. Obviously, we all know FICO scores have become more and more important over the years, but in the last couple of years, Fannie Mae and Freddie Mac, for reasons we can probably all understand in another seminar, decided to adopt risk-based pricing grids. And basically, what they're looking for is a higher payment from people who are higher risk on a loan for a new home or for refinancing. And if you're familiar with these grids, I can provide them. But basically, they're asking for a higher upfront discount charge for the loan when you have a lower credit score, lower FICO score, and a higher loan-to-value ratio. And this thing can be significant. The break points are 20 points on your FICO score. So if your FICO score is 2 points lower, or even 1 point lower than it might otherwise be as a result of a debt collection error or some kind of error on your credit report, what we found literally, it it can your pricing on your loan by up to 1.75% on that grid. So if you have a $200,000 loan, all of a sudden we're telling you that if you can't and we can't help you resolve this problem on this debt collection matter, which you dispute, you're going to have to pay $3,500 more to get this loan, or pay, if you understand the discounting system, or pay up to 3/8% higher on your rate. So this is a significant factor in who has been able to refinance and how much refinancing has been able to occur to help people reduce their mortgage payments and to help move our economy forward, because people are spending less on mortgages. So I want to just, if people really appreciate the significance of one mistake in the debt collection process. That's my major point there. I'm going to make 3 quick points. I'll avoid going through the list of the kinds of things that happen to people, but I can assure you that I've had people who withdrew from their exercise club that's associated with a national franchise, and the guy in the exercise club forgot to take them off the list. They had a credit card hit for $30 for a month. They didn't know it. It went into collection, and all of a sudden they're looking at me, and I'm telling them, if we don't resolve this problem, you're going to pay $1,500 more for your loan to get refinanced.
Mr. Armstrong, we'd be happy to take your written comments and really appreciate your participation.
I want to make 3 suggestions. First of all, I didn't really get a close look at the new portal, but I really, on behalf of my association, appreciate the fact that you're making that effort to make it easier for consumers to communicate. Secondly, I hope the portal is focused and is broad enough so that people who are in the situation that I am describing, downstream, can make that complaint. It's not just an upfront, I'm getting harassed by a credit collector type of complaint. So I hope the portal makes it easy for people to talk about the kinds of things that I'm talking about. I expect it probably is. Secondly, I think that one of the things you might think about is what I would call a reverse tape recording system. Because a lot of consumers complain to me about how they're being treated over the phone by debt collectors. And I know that the credit card companies love to tape record things. Fine.
Sir, there are a lot of other people who want to speak here as well. You can talk to a member of the Bureau outside of this particular public forum. If we have time at the end, we can come back to you. Thank you.
So I'm going to make one more
No,
recommendation.
thank you. We'll go to others, and if there's time, we'll come back to you. Thank you.
Thank you, Mr. Armstrong. Kenneth Wilson.
Thank you. I appreciate that you've come out to the great state of Maine and had a forum here. There were just a couple of comments or issues that I wanted to make, some of which were already addressed. With respect to the portal, I think it's important that, as I believe Mr. Parker pointed out, that there be some mechanism somewhere down the line where there's a sorting out of what are truly complaints regarding treatment of consumers versus what are concerns of consumers but that don't rise to the level of a complaint regarding the collection activity. I think that would give you more valid statistical analysis on those things. Secondly, it was interesting to hear today that the CFPB has put out some action letters for consumers. I would, as a member of the debt collection industry, I know that we for years had asked the FTC if they were willing to put out some guidance for our industry, particularly around the G notice. And it would be, I think, useful to members of our industry if the CFPB would consider making some standard language that would adequately give consumers notice of their debt validation rights while at the same time protecting our members of our industry from technical violations. And finally, to put in my 2 cents, I run a law firm in Massachusetts that does debt collection. The question was asked by, I believe, Mr. Stone, of members of the panel of whether or not a debt collector can provide information regarding the impact of paying a debt on someone's credit information or credit score. From my own experience, the types of information that I get, I don't think it's possible. We have a strict policy in our office that we do not talk at all about credit reporting or effect on credit score because, frankly, we're not experts in that area. How would I know? Thank you very much.
Thank you, Mr. Wilson. Sandra Cloutier.
I work at a credit union right here locally in Portland and Westbrook, and I'd like to make a statement on the mortgage-related rules. In 2013, the CFPB issued final rules regarding lenders, including credit unions, to determine whether a borrower has the ability to repay. We do this already, so we don't feel that obviously this is a problem. However, the rule also sets forth strict definition of a qualified mortgage to include a 43% debt-to-income ratio and 3 points and fees limits. The rule is designed to offer consumers basic protections, a concept that we all agree on and deserves serious scrutiny. In addition to that regulation, the CFPB has issued a number of other mortgage-related regulations, including rules on mortgage servicing. This in our opinion, this has not been fully considered as the unprecedented burden and impact these regulations place on many credit unions. The CFPB rules, in your own words, are significant, complex, and intertwined. On the origination side, doing mortgages that are not qualified mortgages will be riskier and likely more costly. So a credit union such as mine may not find the risk to be justified or worthwhile. On the servicing side, servicers would have to adjust their current practices through gap analysis, capacity analysis, adjusting policy and procedures, upgrading IT infrastructures, training staff, and development of new forms and compliant processes. These changes will have enhancements and a major impact on smaller organizations, and the demand to increase staff in order to maintain compliance with overwhelming changes set forth.
Thank you, Ms. Cloutier, and thank you for giving us the opportunity to encourage credit unions to visit our regulatory implementation webpage. We have engaged in robust conversations with credit unions around the country to ensure that we understand their business operations and the impact to their compliance and legal systems. And we agree with you. Credit unions were not part of the lending that led to the crisis. We're very sensitive to that. And we're very closely monitoring the impact of the mortgage markets on small businesses like credit unions. Thank you so much for raising that.
Let me ask you two questions, Miss. What's the size of the assets of your credit union?
$2.5 million.
$2.5 million? Okay. And the loans you're talking about, do you sell them in the secondary market to Fannie and Freddie or FHA, or do you keep them in portfolio?
Currently in portfolio.
Okay. Those are all qualified mortgages under our rule. So there's not a mortgage you're making that won't be protected with the highest status of protection here. And mortgages you service fewer than 5,000 mortgages?
Yes, we do.
So you're largely exempt from many of our servicing rules as well. So anyway, take a look at our page. We're trying to get word out through the associations about the actual impact of these rules. I think some of the anxieties which existed initially and we understood have turned out to be substantially overblown, but we want to make sure that everybody understands that carefully.
Thank you.
Joanna Murphy. That concludes the field hearing on debt collection in Portland, Maine. Thank you, everyone, for joining us here today. What you have to say to us is very important. We take it to heart. And thank you to those who viewed by live stream.